Yeah, so
Selling after that will be a lot more.
Well,
Yeah.
everybody.
Yeah.
Thank you so much for being here on this Friday. It actually feels like springtime right now, right? It's like double-digit weather. Thank you so much, Nicole, for being here. So as you guys are aware, December 1st, there was some changes. Real estate, something in Brokers Act, what is it? Real estate.
It's right there.
Before. What was it?
Reba.
What was the first B?
Reba, yeah.
So Reba is no more, and we have TRESA, and I have an expert speaker, Nico from Marathon Law, that's going to break it down for all of us.
Yeah.
He has a presentation, but of course, majority of the time will be spent with all the questions that we might have, changes that we need to pay attention to, and I'll turn it over to Nico.
Thank you, Sal. I really appreciate that. It's good meeting all of you. My name is Nikhil Bajaj. I'm a lawyer with Marathon Law. I've been in the industry for about 8 years, since 2015, almost 9. I used to be a partner at a law firm in Vaughan. Marathon Law, as of right now, is 2 partners. We have a support staff of 5, a couple of clerks, bookkeepers, accountants. We're based out of Vaughan. We also have an office in Mississauga. So there were recent changes, obviously. The new TRESA rules have kind of shifted where, where realtors stand in terms of protecting themselves and protecting consumers. There is a little bit of convolution and confusion when it comes to interpreting the act, but that'll obviously come with time, hence my next slide. So it's essential to recognize that the regulations and laws discussed here have not been applied in practice, and any interpretations are based on understanding as of the current date. Furthermore, it's crucial to acknowledge that legal frameworks are subject to change, and governing bodies may modify or interpret these rules differently over time. What does this mean? It means that there's going to be precedent set in terms of how these rules are going to be followed and implemented, and people can always change them. So a lot of the stuff that's happening with TRESA right now, people are against, like the mandatory information guide that you have to give to your clients now. It's about 12 pages. So there's also going to be a section in the working with a realtor apparently that's going to have a section that you acknowledge you received this guide. So people are saying, isn't it a little bit redundant to have both? Have them sign this acknowledgement and also having them working with a realtor. So that's going to come with time, whether or not they're going to amend these rules and change these forms. So things are going to change in the next couple of months. But as of right now, obviously your forms have been updated. Whatever's happened in the past will stay obviously status quo. But yeah, I'll move on to the next slide. So there's a lot of stuff happening with TRESA. There's a lot of confusion as well. These are like just recent article headlines that have been in the news. Everyone's making assumptions as to like what's the difference between customers, self-rep, designated representation, multiple representation. So I'll go into detail about that as well to kind of clarify any questions that you guys have. So TRESA is replacing the Real Estate and Business Brokers Act, REBA, and phase 2 of the new regulations are effective as of December 1st, so they're already in play right now. As of right now, there's going to be 3 phases of TRESA. 1 phase has already been implemented, 2nd phase was implemented a couple of days ago. So phase 1 was completed October 2020. This is when you had the ability to create your own PREC, so you're an incorporated real estate entity. So that's already taken place. And one of the changes was you could only use realtor if you're in good standing. If you're not in good standing, you can't have realtor in your social media platforms, any advertising on your website. You can only use realtor, sales representative, if you're in good standing. Phase 2, obviously, on July 26th, the government of Ontario introduced their 2nd phase where everybody had assumptions as to what was going to happen. So now we're in phase 2. Phase 3 obviously is going to happen sometime next year, which I'll get into later on in the slideshow. So, background on TRESA. So why is this change being implemented? Consumer protection, new tools for realtors. There's obviously going to be more regulation with more power when it comes to RICO, which I'll also go into detail. So the 4 main things, obviously TRESA is huge. If you actually read the Code of Ethics and the regulations, it'll probably take you hours to go through everything. These are the 4 main topics that are being discussed and the most substantial changes when it comes to REBA and TRESA coming in place. One is multiple and designated representation, self-rep, sharing contents of offers, which is a huge change for all realtors, and written agreements and disclosures. So what's multiple and designated representation? So when you guys think of multiple representation, what comes to mind? Like, what is multiple representation?
You'll present with double side.
Yeah, but there's 2 scenarios. One would be basically where you're under the same brokerage. Another would be if you represent the buyer and the seller, right?
Yeah.
So what they're doing now is they've introduced designated representation. So multiple representation, obviously the services that you provide are very limited. None of the clients are fully represented or advocated for. Now, when you represent a buyer or seller under the same brokerage, at the end of the day, you want to advocate for your client. But under the old rules, when it was multiple representation, they felt as though you couldn't fully represent your clients under multiple representation because there was risks associated with it. So for example, clients do not receive any advice that will put their interests ahead of other clients. You cannot do this under multiple representation, such as the price they should offer or accept or terms that should be included in an agreement of purchase and sale, such as conditions, for example. If the client relationship is created between the brokerage and the client, then multiple representation can occur if a buyer and seller use the same brokerage, which I mentioned before. So what is designated representation? The proposed model of designated representation calls for multiple representation still to be an option, but adds designated representation. So essentially, this gives the option to work with both the buyer and the seller under the same brokerage and fully advocate. And now it's kind of confusing, but they just made it clear that even if you're under the same brokerage and one person represents the buyer and the seller, there's basically nothing that can be shared. You have to fully advocate for it, and the brokerage has to stay neutral. They cannot get involved. So it's as if you're at different brokerages now. So they made it a lot more clear to make the consumer and the realtor understand that your rights will be advocated for if you go under designated representation now. So that's what it means. Yeah. So, sorry? Yeah.
I just want to give us an example.
Yeah, I have an example as well. Yeah.
It means that if the buyer is, seller agents from the same brokerage right now, they have a representation by different agent. Right now, it's not called multiple representation, right?
So multiple representation will still exist. If the same agent represents the buyer and the seller, it's multiple representation still, right?
Okay.
Before, if it was the same brokerage and there was a buyer and the seller, it would still be multiple representation.
Okay.
So now what they're saying is that you have the option to do something called designated representation. What that means is that essentially your rights, and I know it's confusing because we're going to see how this. Yeah. So what they're trying to make clear to the consumer is that, listen, you're not in a multiple representation situation anymore. Now you're separate if you're under the same brokerage. It's called designated representation.
Oh, so that means now you cannot present both buyer and seller at the same time. So you have to find another realtor.
So
That's okay.
So multiple representation was two scenarios,
Yeah.
right? One is if you have buyer, seller, two different realtors, but under the same brokerage, right?
Yes, yes.
Or if you represent the same client, client is the buyer and the seller. So they're basically saying that now, even if you're under the same brokerage, now you can go under something called designated representation. Yeah, that's all it is. It's not multiple representation anymore. So basically, you have to be quite honest, it's just for the sake of changing the name.
Oh, it's name, yeah.
No matter what, if you represent the buyer or the seller, even if you're in the same brokerage, you have to advocate for your client. But when you give them that multiple representation form, it would essentially tell them that you're in a multiple representation situation. There may be things that may not be hidden from the buyer and the seller because you're under the same brokerage. There might be a conflict, but that won't exist with designated representation. So this will also protect you, the realtor, but it'll also protect the consumer. Because multiple rep, they can always say, oh, you're under the same brokerage, therefore you didn't advocate for my right. Now this says, no, I'm your designated representative, you signed this agreement, we advocate for you even if we're under the same brokerage. So they've made it a lot clearer now, saying that it doesn't matter if you're under the same brokerage, if you're under a designated representation, you will advocate for your client individually. Does that make sense?
Yes.
So it's clear, that's all it is. Yeah. So obviously, realtors will have to disclose the differences between brokerage obligations if you're represented in multiple representation or designated representation. The proposed model of designated rep says that the duty owed to the clients would apply to the designated agents within a brokerage for the specific identified transactions, not the brokerage and all its realtors. So think of it as the same scenario if you're at different brokerages now. So it's designated representation, not multiple anymore. So here's an example. XYZ Realty has a listing and the brokerage also happens to represent a buyer that's interested in that listing. In other words, the brokerage represents the seller and the buyer. Today, that is known as multiple representation, well before December 1st. In the proposed designated representation model, the listing agent will be able to represent the seller, while another agent of XYZ Realty Inc., the same brokerage, would represent the buyer on behalf of the brokerage to advocate solely for the buyer. So now you're representing your own buyer or seller's interest individually, no more multiple representation situation. The brokerage will retain oversight responsibility for the designated agent's fulfillment of the duties to the clients, but they would have to stay neutral at the end of the day. They say, you guys are separate agents, you advocate for your clients, we can't get involved, it has to be a neutral stance at the end of the day.
I have a question.
Go ahead.
What if I'm the single broker on record and I don't have anybody else that listed the property, someone want to buy it from me without any, so I'm the only one?
Representing buyer and seller,
Yeah,
multiple representation.
okay, so it still exists.
Yeah, it still exists. Yeah, it hasn't been eliminated, but the problem was when you were using one multiple representation form for a scenario where you represent the buyer and the seller, and the same multiple representation form when you're at the same brokerage, it's kind of convoluted because at the same time, it's like you have to advocate for one client over the other. How is this multiple representation when there's two separate agents? Even though we're at the same brokerage, it made no sense. If you represent the same client on the buy and sell, that's 100% a conflict when you think about it, right? But you disclose it to them with the multiple representation agreement. But if you're at the same brokerage, somebody can come back and say, hey, I signed this multiple representation agreement even though there was two separate realtors, you didn't advocate for me. But that shouldn't be a conflict because it's two separate realtors at the same brokerage. So they made it more clear. Now they've said that designated means you advocate for your client, you advocate for your buyer, your seller, whoever, even if we're at the same brokerage. So now your client can't necessarily come back, and even if they do, they have a weak leg to stand on and try to come back after you because you said, no, you signed this, I advocate for you, they advocated for their client, we're good to go. So there shouldn't be any issue. Does that make sense? Yeah.
Solutions, call me, okay?
Yeah, so this is just literally, so you have to basically, designated representation agreements, you have to determine them at the beginning of the transaction. Again, multiple representation will still exist. So this will ensure transparency that each party can be represented without a conflict. So every single person is on the same page at the end of the day. That's all it is. So self-rep. So under REBA, obviously there are two definitions. You were client or you were customer. So customer is being removed from all the forms. You won't see customer anymore. It's going to be client and self-represented party, otherwise known as SRP. What's SRP? It's a party who is not a client of any brokerage. The best analogy I can give you is, have you ever heard of people going to court by themselves? Like there's a family law dispute, one person has a lawyer, one person's fighting it themselves because they don't want to pay a lawyer. That's what self-rep will be. They're basically representing themselves in the transaction. They will essentially have no protections by the brokerage. So what this is saying is that if somebody approaches you and says, hey, you know what, I want to represent myself, you no longer have to make them a customer. You say, no problem, here's this form that says you're an SRP, you acknowledge, you sign this. If anything happens in the future where they're like, oh, you took advantage of me, you're a realtor with skill and knowledge, nope, you were self-represented. You had the option to seek legal advice or a realtor. The self-rep form actually will say you have had the ability to go consult a professional, a lawyer, or a realtor before you sign this form. So it's going to protect the realtor at the end of the day. Now they can't come after you and say you swayed them one way or another. That's literally the only difference between customer and self-rep. So it makes it a lot clearer and it also protects you guys a lot better in the long run.
My question to this though, how do they get paid from these people?
So you
We used to be able to get from the
You
customer,
can't,
right?
you can't. So you cannot get paid in self-rep situation. Nope, you can't. If you're getting compensated.
Good question,
yeah.
though.
If you're getting, that's a good question. Yeah, the money. If you're getting paid, technically you'll end up representing them. They have a limited customer now. So again, SRP can receive general information related to the business of trading in real estate, like general real estate market statistics. Obviously, you have to be careful. Realtor can provide assistance to an SRP if that assistance is a service to their client. For example, as a seller's representative showing the listing to SRP. However, the SRP is engaged for services only, not a duty of care. You don't owe a duty of care to the SRP essentially. So should the SRP wish to purchase the property, the realtor may assist the SRP with the mechanics of filling out an agreement of purchase and sale. But I still recommend that you try to stay away from that, only because you don't want it to seem that now you're in a client relationship. So they've said that you can help them, but as soon as you start helping them, you go more into them being a client as opposed to a self-rep, even if they sign the form. So it allows you to do that, but I would say let them figure it out on their own or go to a professional to do it, whether it's a lawyer, whether it's another realtor, whether it's a friend, because then you're going to be creating a relationship between them where they can come after you and say, you pushed me to do this. I was technically your client.
But usually, I just want to know, buyer usually they don't really need to pay the commission, right? I mean, the people who all separate for the seller, so the seller party, they usually can use this one.
Which one?
SRP, the people they self-presented by themselves, usually.
Well, you can't double end anymore, that's what.
I mean,
What
the
it is.
seller usually they can use this because they don't need to pay commission. Because for the buyer side, I mean, they don't really, because they need a realtor to help them, they don't need to pay any commission, right?
I mean,
For seller,
you could still double land, but they would be that would be multiple representation, right? They would be your client,
Yeah.
but if someone's self-rep, they're not your client anymore.
So then you wouldn't double end.
And then you wouldn't
get
double
paid.
land. Yeah, so let's say they don't wanna give any commission, they're like, you know what, at the end of the day, we are representing ourselves.
But aren't we charging the seller the 5%?
What do you mean?
That's your agreement. So that's your agreement. You don't have to rebate the client.
So I still get 5%.
I mean, that's whatever you decide with your client at the end of the day,
Just
right?
don't sign it myself by myself. I give you 3%. Don't do that.
So how do we engage with a self-rep party? So Section 10 of the Code of Ethics, realtors will be prohibited from providing services, opinions, or advice to an SRP. However, as a service, the realtor's client assistance may be provided to an SRP after the self-rep party has received the mandatory RICO information guide. That's the guy that we were talking about originally. It will be the responsibility of the realtor representing the brokerage to provide an explanation of the documents to an SRP at the end of the day.
Sorry, I just have a question. If I'm a listing agent, who call client call in and ask for showing the property and say there's nobody to represent himself or herself? That means I just say no, because they're self-represent themselves.
Well, the only time they would technically become designated as an SRP is if they sign that acknowledgement form. You can always sign them on as a client at the end of the day, but you can't sign them on as a customer anymore. SRP would just be a scenario where they sign the acknowledgement and they're dealing with everything on their own. But if you're helping them and guiding them, technically they're a client. You would be in a multiple representation situation in that scenario. Whatever you decide in terms of your commission, that's something you would have discussed with your client at the end of the day. Who's going to pay the commission, who's responsible, how much, those kind of things. But SRP situation is basically eliminating the customer relationship. No more customers. Now it's literally solely they're responsible for everything on their own. But if you start guiding them, you might unilaterally create a client relationship at the end of the day, even though they've signed something. Because if you start giving client services or they start paying you under the table, whatever it is, they're not a self-rep anymore. They're essentially a client at that point. So you want to make sure you make it clear from the beginning, make sure they sign that acknowledgement, make sure they understand it, and that they can go to somebody else for advice.
So question, her scenario is she listed a property, you called to want to see the house. I need to send that guy to sign before I show them for my sellers?
What do you mean?
No.
Because, for example, you're not my client, you're
Yeah.
calling me and saying, hey, Christine, I see a Southside there, I want to see that property.
Yeah.
So in this cases, you don't want, I said, well, I'm only showing that as my
You would-
client.
You would have to be there. So if they want to see the property and they don't have a designated representative to show the property, you would have to basically show the property. A realtor has to be there at that point.
Do we need them to sign this
Info guy.
info guide to say that they are the SRP?
A self-rep,
Yeah,
100%. Yeah, get them
so
to sign
before we even show them.
You would ask them, are you working with a realtor? Because you always ask that question first.
Okay.
Are you working with a realtor? No. Would you like to work with a realtor? Sure. What options do I have? Well, you know what? This is the multiple representation agreement. These are the rights that you have. If you enter into this, this is what happens. There might be a conflict, et cetera, et cetera. But you also have the option of being a self-rep. So can you please sign this agreement as a self-rep? So you would probably want them to get to sign that self-rep agreement.
Right.
Every time somebody comes to see, every time someone comes to see the property, it's not like they have to sign the self-rep every time they come to see it. But as soon as they want to make an offer on it, they would have to sign it. 100%. Yeah.
That's a question.
Because that would be burdensome. Yeah,
Well, in that case, is why an agent want to show people,
that's up to you, right? At the end of
For
the day.
separate, right? There's no point.
yeah.
So don't sign it, don't offer that.
But that's the service you're providing to your
Why I
seller,
say
right?
several times, say, no, I'm not gonna show
Showing
you
the property to prospect.
So what do you do in this scenario now when somebody reaches out to you and wants to see a property but they don't have a realtor?
I said I
to
need
work with?
to have you sign a buy agency agreement. No,
Okay.
I don't know you, I don't want to sign it, then you
Okay.
have to find somebody else.
Okay.
Exactly. Exactly.
Okay.
I think under the RICO, as a listing agent,
You need
you owe
to the seller, you have to keep your seller's interest, at heart. Make sure that you show all the property to all the potential clients, right? Under the recall. So sometimes they might complain you to the recall, saying
Yeah, that's my
sure,
concern.
right?
Like if.
You could get a complaint because you're not having the seller's interest at heart. Because you have to show the property to maximum potential buyer available on the market, right?
The way I look at it is, this would be a great opportunity for people to get under agreement from the buyer's side. I'm a listing agent, sure. I would want to show you the property. This is what your rights are. Please sign this so I can show you the property.
See, the practice of being a realtor, SRP makes sense if you're a seller, right?
Yes.
But if you're a buyer, at the same time, it's not the buyer that's paying the commission, right? So in the scenario that you gave me right now, it makes sense, but he's also right. You can't technically force someone to sign an agreement, right?
Nope.
You would have to basically allow them to come see the property because you're giving more exposure for your seller as well at the same time. But at the end of the day, everyone operates differently. So you have your opinion, I respect both.
I think you know you might get in trouble by not showing the public.
But you also want to protect yourself as an agent at the end of the day, right? But yes, I see where you're both coming from. Yeah. But
I guess just like for sell by owner, right? There's a chance that you can actually provide service to for sell by owners. Does that make sense? So if you go to first sell listing, and they're representing yourself as a first sell by owner. So now your goal is to go in and say, hey, how can I help you? What service am I providing you? How am I going to make the most amount of money? Right? Turn over to buyer side, saying, hey, you're not paying anything. How am I going to help you? Right? By providing you service. That way, I think it's a win-win situation.
That's a good point. So written agreements and disclosures. So prior to TRESA, it was not clear exactly what services a realtor was providing, the cost of these services. Under TRESA, everything such as the services being provided, the cost of these services, including remuneration, will have to be clear. What does this mean? If you have a listing agreement, you must specify what you're doing: staging, remuneration, photography. You have to clearly state that now in every single agreement that you have with your client. They want there to be more transparency for consumer protection at the end of the day. Because they might say, oh, I didn't tell you to stage my property. Oh, I didn't tell you to put photos of my property up. So now you have to be very, very clear when it comes to written agreements and acknowledgements.
Is there a form available for that?
So you would put it essentially on a listing agreement now. So you'll have a section where you can literally stipulate how much you're going to charge for staging. I know for you guys, you just take 1 month or 2 months, and then you're gonna pay more.
We do that anyways on the side, when it's some.
A lot of realtors do.
Yes.
And you guys also have agreements like if it doesn't sell, then we'll be compensated.
We do that.
Yeah. So TRESA will require more clear and concise language. You must obtain a written acknowledgement from the client indicating the disclosure has been received. Once the written acknowledgement is signed, a copy will need to be provided to the client. New listing agreements provide for a new menu of services. I don't know if you guys have seen the new listing agreements.
No.
So ORIA's existing standard form includes space to insert the cooperating broker's commission. However, the decision of the seller on how much remuneration is payable to any other brokerage, it needs to be a conversation that happens between the listing brokerage and the seller. So, contents of written agreements must clearly outline the circumstances where the payable remuneration may change. So I know in a lot of situations, if you guys do multiple representation, you might discount your commission, right? So let's say, I think the going rate's 5% if you're listing and if you're the co-op, right? So a lot of times, if you're representing both parties, the listing client might say, can you discount the commission to 3-4%, whatever it is. So technically, you won't be able to unilaterally make that decision until you have it in writing. Make sure you get it in writing. Make sure you get some kind of agreement signed or an email that stipulates that this is the remuneration and this is how it's going to be changed, specifically in a multiple representation situation where somebody wants you to discount their commission, if you're willing to discount their commission. So in practice, some listing brokers may reduce their remuneration if the listing agent also represents the buyer in a transaction, multiple representation. Moving forward, this practice is not allowed and needs to be a part of the written requirement, so everything has to be in writing. Any services promised to a client, as I mentioned before, professional photography, staging, open houses, must be listed in the written agreement.
Yeah.
So everything has to be concise and transparent now. I mean, a lot of realtors have been already doing this, nothing's really changed, but in the code of ethics and the new rules, they just want to make sure it's more transparent and clear.
So Nikhil, for that open house, does it need to be specified by the listing agent himself or by other agent in the brokerage or other agent not in the brokerage?
So in the actual agreement itself, you'll want to put in that, you can put like a broad clause, which I can even help you draft, that stipulates that you're giving us the authority to stage your house
Okay.
for whatever this price range is or whatever the hourly rate is, whatever it is. Photography, unlimited open houses until the listing agreement expires. So you want to make sure it's clear in the agreement,
Okay.
just so they don't come back and try to complain. Because there are scenarios where people say, oh, you're showing my house to too many people, like what's happening? Or like, oh, I want to use my own furniture, why is the staging still there? Very rare, but it happens, sometimes clients complain. We had a recent situation where this realtor went in and he went in with 2 other people and they started making TikTok videos in the house. And there was no consent given by the seller to do that. So they used their house as basically a venue to make TikTok videos. What they didn't know was that there was cameras in the house at that point. So the seller actually complained to his agent, complained to Rico, and made a complaint against the agent who was making the TikTok videos. So if you're gonna make TikTok videos, make sure you put in the agreement. That's all I'm saying. Just as a hypothetical. Yeah.
And it's media, not social media, all of it.
Yeah, social media.
YouTube.
So consumer information guide, Rico released a mandatory information guide for consumers. Now there's a lot of debate about this, whether or not it's gonna still remain 12 pages. The information guide prepared by Rico is mandated and is the only acceptable version of the information guide. You can't make your own, you have to use Rico's, the one that you have printed. Brokers are not permitted to create their own information and must provide consumer with a guide that is prepared by Rico. Before you provide any services, I know this is a little bit burdensome and onerous, before providing any services, you must present this disclosure and agreement to your clients for them to sign. Now, every brokerage operates differently. I know EXP has a lot of requirements when it comes to, I think you use SkySlope, right? Where you have to upload certain things and make sure FinTrack forms comply with certain parameters. I'm sure this is going to be a requirement for SkySlope as well, I'm assuming, because at some brokerages, they're a little bit more easygoing when it comes to compliance. I know EXP is a little bit more stringent, so I do see this becoming a requirement for the purposes of complying with your requirements for SkySlope. So I'm going to go over this. So this is kind of what the first page looks like. So what is the information guide? It goes over duties and obligations registrants owe the clients, obligations of clients, benefits of benefits of being a client of a registrant and being a realtor, remuneration arrangements, how to bring a concern or file a complaint with Rico, which is going to be one of the biggest changes, which I'll go over as well. So this is probably the biggest change I think that you guys are going to encounter, sharing contents of offers, and I'm sure you're already aware of this because everyone's talking about this. So in TRESA, sellers have another option to negotiate the sale of their property. If the seller directs the brokerage, TRESA general regulations allow for the details of competing offers to be shared with other buyers. No personal information may be disclosed or any other information that would identify the person. It is important to note that it will still be a requirement for a broker to disclose the number of registered offers to competing buyers. What does this mean though? So at the end of the day, you can basically talk about price, deposits, conditions. You want to have a written arrangement with your seller at the same time, because everything has to be acknowledged by your seller. You can't unilaterally make that decision for them. You have to have an email, something in writing from your seller that stipulates, I want to share the conditions, I want to share the deposit, the price, or a catch-all. You can share all the contents of the offer, but nothing personal, obviously, because that would go against legal guidelines. So this is going to be huge because this will allow you to leverage certain offers in this market. Sellers will have the ability to instruct their agent on how much information they're permitted to share, so they can always say, I don't want to disclose the conditions, but I want to disclose the price, which I wouldn't see why they would do that, because the more they disclose, the more leverage you have at the end of the day. So why are people doing this? The process becomes fairer and more transparent. Buyers will have a clearer picture of competing offers at the end of the day. And this is being done in other provinces as well. This is just new for Ontario now.
But is that mandatory? Like if my seller doesn't want to?
If your seller says, I don't want to disclose anything, you can't disclose it.
We have to write it down.
You need written directions from your seller. So an email,
Either or no?
Pardon?
Either or only when they choose to disclose it.
So before you disclose it to the buyer's agent,
Right.
you need it in writing
If
from
they
your
choose
seller.
not to disclose,
If
you
they
don't
choose
need,
not to disclose
you don't
it,
need that
you
form.
don't need anything, yeah. But I don't see why the seller wouldn't, because it helps them at the end of the day, right? So,
it depends.
okay.
What if seller choose to, disclose some information, but, one of the offers from one of the buyers put a clause saying, I do not want, the contents of my offer to be disclosed.
That's a good
It's up to
question.
the seller.
Yeah.
That's precedent's gonna show what's gonna happen in that scenario. I wouldn't see how you could bind that. So you're saying that the buyer would put a clause in the offer that stipulates that I don't want my offer being shared with.
Yeah,
other
with
people.
other competing offers.
And then you probably wouldn't be able to disclose it, because if the seller signs off on it, it's a binding contract, they have to abide by it, right?
Yeah.
Yeah, but I wouldn't see why the seller would agree to that, right? Unless it's a very strong offer.
Mm.
Yeah.
So,
That's like them putting a clause in saying that I don't want you to register any of the offers, but it's a guideline that you have to basically register each offer that comes in. But in that specific scenario, if the seller signs off on it and doesn't contravene any of the other rules of TRESA, then I technically you'd be bound by it, because it is a contract at the end of the day, right? Yeah.
Even in that situation, is the listing agent still able to share, the contents of other offers to other agent except that
no,
one?
I would cross that out and back to the agent when they said, we gotta take that out. You must-
If that scenario happens, and like I said, like a lot of the stuff there's been no case law on this as of yet.
Yeah.
But in that scenario, if the seller did sign off that he wouldn't disclose other offers, I would say that he is bound, because at the end of the day, you signed this contract that binds you to make, you basically have to operate within the four corners of the contract. So if he signed off and literally agrees to that, I wouldn't see him having the ability to actually go and disclose other offers, because he's breaching this agreement at the end of the day.
Okay.
I wouldn't see why somebody would do that. Yeah, or agree to that. TRESA and standard forms. So it's obviously been extensively reviewed. There's 30 new ORIA forms, and being possible to go over each one. 60 revised ORIA forms and 29 discontinued ORIA forms, all effective December 1st. Whatever is before December 1st, if it's been signed, it's still binding, it still exists, even if it's a customer agreement. The new ORIA forms fall under varied categories related to self-represented parties, client relationships, seller directions of brokerage, communication with integrity, etc., etc. So I would say when you have free time and want to do a little bit of light reading, go through the 30 new forms and maybe the 60 revised forms. If you have any questions about the forms and how to interpret them, you can always contact me and we can go over the forms. Code of ethics. So there's a new code of ethics. It's a lot clearer now. So they moved to the general regulations. This means code of ethics articulates the requirements of every realtor, which is integrity, quality, and service. So it's much smaller than the old code of ethics. So this is huge. RICO's discipline process. So RICO has much stronger and much broader powers now. So the introduction of TRESA was a result of ORIA's own advocacy to set higher standards. Previously, RICO's disciplinary committee could only handle allegations of non-compliance with the code of ethics, but now they have authority to take on any compliance failures related to TRESA. So what does that mean? So essentially, RICO's discipline committee will now have the ability to suspend, revoke, or apply conditions to any realtor, which is obviously huge. So they can essentially revoke your licenses. They can also investigate a realtor's conduct and refer them out to the discipline committee if, whether a formal complaint is made or not. They can also bring in experts to look through your records. So RICO's powers are much, much broader and much more powerful now.
Who was doing all this before? No? Nobody?
So at the end of the day, it go to a tribunal and then they would essentially make a decision, but now RICO can RICO at the end of the day could investigate a complaint, right? But they couldn't suspend or revoke your license. They had no control over your license. Law Society, if I do something wrong, they can take away my license, they can revoke it, they can suspend me.
So we're fair now,
RICO never had that power before. So this is huge, and it's good too because it'll basically filter out a lot of people who do abuse the system. Because at the end of the day, RICO looks over the complaint, it takes a while, people go back and forth, lawyers get involved, and then eventually goes to a hearing and can take some time. Now RICO can do this themselves, if they, in their discretion obviously, but we're gonna see how it plays out and when they're gonna actually use this. This is gonna be a very powerful tool for a lot of people. At the end of the day, if they choose to revoke your license, that's people's livelihood at the end of the day. So you have to be grossly negligent for them to actually revoke someone's license. So how does it work? So the discipline committee will consist of 5 or more members. At least one of those members must not have a connection to the real estate industry, just so they're not biased. Any appeals of RICO will go to the LAT, Licensed Appeal Tribunal, which is an independent quasi-judicial tribunal. When I used to do litigation, we used to deal with LAT all the time when we did mediations. The resulting discipline, including the reasons for revocation or suspension, will be made available to the public. So if something happens, you get your license revoked, everyone will essentially have access to it. So phase 3, obviously, there's going to be a phase 3. When that's going to happen, probably sometime next year. So regulations to support specialty certifications for realtors and brokers, improving continuing education, rules for new admin, money penalties for black and white violations, updating RICO's registration process to reduce red tape. So there's a lot of rumors as to what's going to happen with phase 3. A lot of people are hearing about the cooling off period. There might be a cooling off period for resale properties. Nobody knows at this point.
10 days, right?
Yeah, so we're going to see once they actually implement phase 3. And that's pretty much it. Please.
What about sellers not paying the buyer's commission anymore? Like we have to negotiate with the buyers for the commission, the cooperating commission.
Okay. You're saying for a self-rep?
I think they're doing that in the States, like some of the states.
Okay.
So like,
There's a whole lot.
so now you have, well, all the commission is negotiated with the seller of the house, right? So you have to pay the listing agent and then 2.5 to the cooperating.
Okay.
Is it gonna be like, I'm just dealing with the seller on the listing commission? We're not paying the cooperating commission?
No, you're still gonna have to pay the code. Like,
It's like it's
But will it be later on, like, will they adopt the same thing that they're doing in the States?
It's
nobody
very much
knows.
like
Nobody knows. That's something that I can't comment on because nobody knows that.
Okay.
Yeah. Phase 3 we'll find out, but it doesn't. It's happening in the States. I mean, I wouldn't see why it does. Yeah.
But you haven't heard anything?
No, not about that. The only one that I've been hearing a lot about, and people keep asking questions, is the 10-day cooling off period for resale properties.
Okay.
Which, I mean, at the end of the day, like, where does it stop? Because condo makes sense because it's a huge 100-page contract that you're signing for a pre-con, so you need time to go.
And you're not seeing the place in person, like.
Yeah. So resale is kind of like, it's like signing a contract at the end of the day. So are they gonna put 10 days on contracts now? So like when's that gonna actually stop?
Yeah.
So I don't think they're gonna do that. If they do, I think there's gonna be a lot of, fight back because that gives you 10 days to investigate what else is out there in the market.
Yeah, it's not fair to the seller.
what I also raised the question is that is it only to the buyers or to the sellers? Do they both have the same right to evoke 10 days?
For the realtors?
Yeah, if they're gonna implement the 10 days.
Oh, buyers, you're saying
Sellers and buyers, right?
Just the buyers, I think.
for what?
The cooling off.
Oh, the cooling off period. We'll
It's
see.
impossible to sell the house.
Yeah, we don't want to open up the can of worms, right? So
Yeah,
They should not.
if they're gonna award that right to the buyers, my sellers want it too.
I mean, think about it this way, when it comes to pre-construction, when you're dealing with a builder, the cooling off period only applies for the buyer, right?
Yeah.
So the seller's already stuck, the builder's already stuck. Because if the buyer decides to say, I'm waiving my cooling off period, vendor can't back out of the deal. So I would see it applying the same way. But it's just a slippery slope going down that road, giving someone 10 days to figure out, like, an APS and OREA form is not that convoluted, it's not that long, things are pretty basic.
Yeah.
It's designed for a layperson to fill out at the end of the day. You guys just help them facilitate it, or if it's a complicated transaction, let's say commercial, agricultural, then you step in with your knowledge. But it's not too complicated or comprehensive to understand for like a layperson at the end of the day. That's the way it's designed. So giving someone 10 days just gives them 10 days to shop around for another property, in my opinion, at least. But I wouldn't see it applying to the seller in that case.
So I mean, being a seller,
Yeah.
if the buyer has 10 days, I want the same thing. If I saw it's cheaper to this guy within 10 days, someone else offered me more, I'm gonna not selling to himself, as an agent, I want to fight for that too because I make more
You
commission.
should sit on the committee for RICO.
Yeah.
Definitely.
Please don't.
Yeah, I know. We'll see what happens, but the main reason for these new TRESA rules, it's to not only protect, clients, it's also protect realtors to create more transparency at the end of the day, right? Because a lot of times clients are confused as to what they're signing and what their protections are. So these new forms, obviously they're onerous, and a lot of people don't like the fact that you have to go through these extra steps. And things might change, right? Things might change in the next 6 months because there is a lot of, there's a lot of animosity towards these new changes, but I think a lot of them do benefit you at the end of the day. especially the fact that you can share contents of an offer now. I think that's huge for you guys, in my opinion at least.
I think one of the biggest things is there's no customer service agreements. So if you want to represent a buyer, there has to be a representation in place. Because a lot of times agents would get the pushback that we don't want to sign a BRA, but we don't want you to show properties to us. So that eliminates that altogether now.
So there's no more customer service agreement, just self-rep,
Yeah, but also it's important that agents take advantage of this change and actually do the necessary due diligence, right? Like when people want to sign a buyer agreement with you, they trust you. So and if you're the listing agent and somebody wants to see the property that you have listed and they choose to sign or not sign a BRA with you, you still owe your sellers the due diligence, not just bring any random person to see this $2 million property. So if they're signing a BRA with you, there are some necessary checks that you must do, qualification-wise, down payment-wise, what kind of job do they have, for example. Regular things, right? It's not about just, I'm only gonna show your property if you sign a BRA with me. No. Do they even qualify to buy this $2 million house?
But that's where she's brought a very good point, the lady here, that what am I gonna say, and she said it beautifully, that I'm not gonna be showing you the property if you don't sign.
Yeah, and also like as a listing agent, it's your prerogative if you choose to show the property or not, because we also owe it to our sellers to show it to as many people as possible. It's the way you run your business,
But we are showing a qualified buyer, not a random.
Exactly, so if you choose not to sign a BRA, then if you don't choose to sign a BRA, these are the things that I need to see, and I would personally show you the property.
See, the problem that I see with self-rep is that if somebody comes in and wants to buy a property, they're gonna ask for your assistance. They're gonna say, oh, can you help me with this, or what does this mean, what does that mean? But now you're a client at the end of the day. So you should be obviously entitled to some kind of compensation or commission at that point.
Yes.
And I'm confused as to how that's gonna play out, right? Because self-reps, at the end of the day, if they don't have anybody guiding them, then they're not gonna know even what to put in the offer, what conditions. So let's say they do, go in firm on a listing, for example, right? What's not stopping a judge from setting that aside and saying, oh, they didn't have a representative representing them, they didn't have a realtor or lawyer helping them with that, therefore they were taken advantage of. So sign the mutual release the deposit at the end of the day. So that's what I'm thinking about, because a lot of these rules are not actually written by lawyers or judges, they're written by the governing body. So they're not looking at obviously what's gonna happen in the future. That's why I think rules will definitely change, and it's gonna be interesting to see how this whole self-rep thing plays out. Because at the end of the day, they're not gonna be represented or protected down the line. And if they do try to contest something, someone might take their favor, or might take their side, as opposed to, favoring our side, saying that, no, they signed acknowledgement for self-rep, they knew what they were doing, they had an opportunity to seek legal advice. So I think precedents will be set, and just the future will tell what's gonna happen with these new changes for sure.
I have a question. This going further, I'm all for transparency and providing necessary rights to the consumer and the realtor. But is RICO or the governing body showing some precedents or some cases that have happened to why they've done this for lawyers like you to access and set a precedent or advise their clients in case, because that's the first plan of action. They'll either go to RICO or they'll come to a lawyer like you saying this is what has happened, I've been done bad by my agent doing so and so, but there's no point of reference as to what's the right thing or what's the wrong thing.
So are you asking, has RICO presented cases as to why they made these changes?
Yes. So
there's no specific cases that they've referenced as to why they've made these changes.
Right.
We come across scenarios where RICO should probably implement rules in place all the time. One being, I think the biggest one is mutual leases, right? When somebody puts a deposit on a property, they're like, oh, I didn't know that if I don't sign a mutual lease, I can't release the deposit, and the only way you can do it is through a court order.
Yes.
So I would like to see them address that situation, what's gonna happen in that situation, right? But there's no specific cases that have actually led them to these decisions. I think they're just trying to create more clarity, whereas things were vague before. But I do think down the line, the next couple of years, there needs to be a lot more changes to the regulations, just so certain things like the situation that I mentioned can also be addressed.
Because it's great for consumers to have a say, but what about the realtor? Because you can be putting 10 things under contract and say, I'm going to be having X amount of people come through this property or do this or do that. That's where the conflict of interest for me, just disturbing something that's already not set, which is our forms basically. But yeah, we'll see and find out what happens.
Yeah, the thing is, there's been a lot of realtors that have become licensed in the last couple of years, and obviously complaints against realtors have gone up as well.
Right.
So I think they had to take some kind of action, even though it might not be something that's substantial,
Right.
or it's going to change, anything for consumers.
Right.
But at the same time, I think that time will tell how these changes are going to be implemented. Do I think they're gonna last? I think there's definitely going to be amendments and more changes, only because certain things like the disclosure, 12 pages, are you actually going to go through the whole thing and explain to your clients? You should. That's your duty at the end of the day. You have to sign that before you even retain them.
Yeah.
But 12 pages is pretty onerous at the end of the day. Or you just tick off the box and working with a realtor.
So the signing part is not even mandatory.
So
I sent an email to my client, they clicked it and got an email saying, you need to keep this in email as a record that they have clicked it.
Yeah.
That doesn't necessarily mean that they've gone through it. Is it mandatory that I go through it with them? No.
So technically, you have to make sure they understand it. You don't have to legally describe every single clause to them. At the end of the day, in that actual disclosure, it goes over their rights. It goes over the fact that they can actually, go and get it reviewed by somebody as well. They have an opportunity to do that. So it is your duty to explain generally what you're giving to them, right? Not just sign, click, don't worry about it, right?
So,
Yeah.
so if we're gonna use you, can we ask them to come through you with
Sure,
this?
yeah. I mean, if you want us to go through 12 pages,
Yeah,
How
California
much
has
money
about 100-page disclosure, so.
Oh, California's 100 pages,
Yes.
yeah.
Huh?
Yeah,
Calgary?
California.
Oh, California. Oh.
Tony Smith uses it in the listing presentation to his advantage, says, this is, we'll share it if anybody needs a listing way, how to handle that.
Yeah.
And they're complaining about 12 pages.
Yeah. 100 pages is a lot. Any other questions?
No wonder they make so much money in law.
In California?
So the Mobile information guide is mandatory right now, right?
Correct, yeah.
Well, thank you.
No problem.